education.
Good afternoon and welcome to this Corney and Lind webinar. My name is Joe Swin. I'm with the business development team at Corney and Lind. Today's webinar is entitled Same-Sex Marriage Legislation Implications. Now, it's going to be presented by Jessica Lipset, who's an associate here at Corney and Lind. Alistair is unable to make it this afternoon, but Jessica will be covering it today, and has a background. And Jessica has a background in litigation. And working with churches on a number of different issues, including a lot of not-for-profit and charity legal issues. So a lot of value we'll be getting out today, so lots to look forward to. I'm going to pass over to Jess now. Just a quick note is that we will be making a recording of today's webinar, so you can check back mid-next week and you'll see it on our website. Also, if you've got any questions, do drop them in the chat box on the left-hand side, but do note that everybody will be able to see your questions. So let's get into the presentation.
Okay, thank you, Joe. As Joe mentioned, I'm an associate with Corney and Lind Lawyers and primarily work for our charities and not-for-profit clients. So you know who we are and the type of work we do, but certainly in this particular area, it's one that we've been following very closely since the legislation changed. So the topic of this webinar is to look into the amendments to the Marriage Act and the implications for churches. So obviously in the lead up to the Marriage Law Postal Survey last year, it was characterised by a lot of public discussion and debate. And once the yes vote did succeed, there was a lot of attention then on what the terms of the actual amended legislation would provide. And in particular, whether there would be adequate protections for religious freedoms that were built into those provisions. So the legislation that passed through the Federal Parliament, it was enacted on the 8th of December last year. It did do more than just change the definition of marriage away from that requirement that it be the union of one man and one woman. But the changes have resulted in some fairly major implications for religious denominations such as Queensland Baptists, who obviously maintain their commitment to the traditional biblical definition of marriage. So those changes actually came into effect on the 9th of January this year. To start with, I think it is relevant to look at the objects that were set out in the Marriage Amendment Definition and Religious Freedoms Act, which is the legislation that was actually passed in order to pass the specific Marriage Act amendments. So from the objects of this legislation, it's quite clear that the legislators were very conscious of the religious freedom implications of the amendments and trying to balance these with the ability for equal access to marriage for homosexual couples. It's obviously a matter for debate whether the objective to protect religious freedoms under the Act was achieved to the extent it needs to be, and that's something that we'll look at later in this webinar. But on the face of it, the objectives were as set out on screen. So firstly, to allow civil celebrants to solemnise marriage between two people as opposed to one man and one woman. Then to allow ministers of religion to solemnise marriage respecting the doctrines, tenets and beliefs of their religion, the views of their religious community or their own religious beliefs, and to allow equal access to marriage while protecting those religious freedoms in relation to marriage. Now the term at subparagraph B of the objects provision, where it says doctrines, tenets and beliefs and views of the religious community, that might seem like overcomplicated terminology for what they essentially provide for, which is the religious freedoms that it's talking about. But both of those terms are concepts that have been considered in case law, particularly around the issue of anti-discrimination legislation. So we'll look at those meanings a little bit more closely as we move through this presentation. Then we look at the key amendments that required all of these religious freedom amendments in the first place, and that's of course the definition of marriage in the Marriage Act 1961. Now the previous definition of marriage read that marriage means the union of a man and a woman to the exclusion of all others voluntarily entered into for life, but the amendment very simply just substitutes the words two people for man and woman. So the definition now reads as on the screen, so the union of two people to the exclusion of all others voluntarily entered into for life. Now, another completely new concept in the amended legislation is the concept of religious marriage celebrants, which did not exist in the previous iteration of the Marriage Act. So under Australian law, only an authorised celebrant can legally solemnise a marriage, and the Attorney General's Department maintains a list of all of the authorised marriage celebrants in Australia, and that's referred to as the Register of Marriage Celebrants. So previously, the provisions of the Act referred to ministers of religion who were entitled to be registered as marriage celebrants on the basis of their credentials from the relevant denomination. And then there were also civil marriage celebrants who had their own application and approval process. So this distinction was relevant because there were different obligations and requirements on religious ministers as opposed to civil celebrants in relation to issues like eligibility and registration and other more administrative matters. Now there's also this additional new category of authorised celebrant, which is known as religious marriage celebrants. These provisions are more relevant to people who aren't themselves credentialed or ordained ministers of religion, because those people would be automatically eligible to be registered on the register as religious marriage celebrants. In fact, all marriage celebrants who were registered as ministers of religion with the current registration as at this 8th of December, so the date that the legislation passed, they've automatically been given this status as a religious marriage celebrant on the register. So, for anyone who is not a minister of religion, as that term is defined in the Act, they can actually apply to be included on this register of religious marriage celebrants. And once that application is approved, there are provisions later in the amended legislation that provide the same protections as ministers of religion in relation to either refusing to conduct a marriage ceremony for two people where that would conflict with someone's personal religious views. So in the context of Queensland Baptists, I understand that both ordained ministers and also registered pastors can currently conduct marriage ceremonies on the basis of their registration, which qualifies them as ministers of religion under the Act. But there might also be circumstances where there are pastors who have been called by the local church but who aren't necessarily registered by QB, and they might wish to become marriage celebrants and have the same access to those protections under the Act regarding marriages that conflict with their personal religious views. So whether or not it's possible for them to register as a religious marriage celebrant will depend on whether the pastor can be classified as a minister of religion, as that term is defined. And that definition actually comes from a taxation ruling in relation to fringe benefit tax exemptions. And it sets out various characteristics which you would need to identify to argue that someone should be classified as a minister of religion. So some of those is membership of a religious institution, if the person is recognised officially by ordination or some other admission or commissioning, whether the person is recognised officially as having authority in matters of doctrine or religious practice, if their position is distinct from that of ordinary adherents of the religion, if they have some kind of acknowledged leadership and ability to do things like conduct religious worship and other religious ceremonies. So they're all relevant indicia that someone should be classified as a minister of religion. So if a pastor was going to seek to become a registered religious marriage celebrant, there would need to be an assessment done of whether that person displays some or all of these characteristics to a sufficient level, which would need to be done on a case-by-case basis. But theoretically, it is completely possible for unregistered pastors to actually gain that registration as religious marriage celebrants and therefore have the same protections as ordained ministers or registered pastors in relation to conducting any same-sex marriage ceremonies. So now we'll turn to look at the key religious freedoms provision in the amended legislation, which is section 47, and that provides that ministers of religion can decline to solemnise a marriage, and they can do that on a few grounds. So firstly, if the refusal conforms to the doctrines, tenets or beliefs of the religion of the minister's religious body or religious organisation. B, the refusal is necessary to avoid injury to the religious susceptibilities of adherents of that religion. Or also at C, if the minister's personal religious beliefs do not allow the minister to solemnise the marriage. Now, importantly, not all of those grounds need to apply for a minister to decline to conduct a marriage. It can be just one of those grounds, and that would be completely sufficient. We'll look at each of these grounds separately in our next few slides, but just keep in mind as we're going through that only one of them needs to apply for the refusal to be considered lawful. Also, just as an aside, there is an additional clause at subparagraph 4, which is on the screen there, and states that nothing in this section limits the grounds on which a minister of religion may refuse to solemnise a marriage. So there has been some suggestion that this could be applied more broadly than just same-sex marriages, to allow ministers to refuse to marry any couple on a number of grounds. One example that's been mentioned and discussed is pre-marriage counselling and imposing a requirement on couples that they attend pre-marriage counselling before a minister will agree to conduct the wedding. It's also been said that this can potentially protect ministers from particular denominations with strict restrictions around the Sabbath or religious festivals, and who might need to decline to do a marriage on a particular day for that reason. Of course, these issues haven't been tested yet because the legislation is so new, but by just a reading of that legislation at its face value, it certainly does seem like refusing to conduct a wedding on the basis of objections like this won't actually raise any issues for churches. Okay, so now looking at that first ground individually, Section 47 permits a minister of religion to decline to solemnise a marriage if that refusal conforms to the doctrines, tenets or beliefs of the minister's religious body or organisation. This is an exemption that doesn't rely at all on the minister's personal beliefs, but it rather relies on the beliefs of the religious body that they're ordained by. So for QB ministers, it's the position of QB in relation to marriage, and specifically whether the views on marriage and sexuality can be considered to be a doctrine, tenet or belief of QB. That's the relevant issue here. The second ground is slightly different, and it permits a minister to decline if that refusal is necessary to avoid injury to the religious susceptibilities of adherents of that religion. Now, religious susceptibilities isn't a common phrase outside of the anti-discrimination legislation, but a simpler way to understand the meaning of that might be religious sensitivities. But again, like the first ground of refusal, it isn't based on the individual minister's personal religious sensitivities, but rather it's the religious sensitivities of adherents to that particular religion. So there's a couple of questions that arise there, because firstly we need to identify what is our religion. Is it Christianity, or is it more specific than that and linked to our particular denomination? And within that, what are the general religious sensitivities that we would consider the norm across all adherents? So fortunately, there are a number of cases that have considered this issue and provided some judicial authority on how we can determine these issues. So what is a doctrine, tenet or belief of a religious body, what the actual religion is that we need to consider, and what are religious susceptibilities, because these phrases are common across anti-discrimination legislation in Australia, so they have been considered quite specifically in that context. However, unfortunately, there are some differing views that are set out in the two leading cases in this area, so there is still room for some uncertainty until the High Court provide us with some further guidance. So we'll look at these cases individually. The first of these is the case of Christian Youth Camps Limited and Cobor Community Health Service, so the CYC case. And that's a case coming out of the Victorian Court of Appeal. So in this CYC decision, the complainant ran a project which provided suicide prevention services to same-sex attracted young people. They inquired with Christian Youth Camps, CYC, which was a youth camping movement and facility which was affiliated with the Brethren movement, and they inquired regarding the use of their campsite. Now, the manager of the campsite advised the directors of Coburg Community Health that the directors would be concerned about making a booking for a group that they said encouraged a homosexual lifestyle. So proceedings were commenced against the manager and CYC, and they sought to rely on the religious sensitivities exemption, which was available to them in the relevant anti-discrimination legislation in Victoria. So a key issue for determination was whether CYC was a religious body, given that at the time the Victorian legislation limited the exemption to religious bodies only. And the majority in this decision concluded that the exemption could not apply and that CYC was not a religious body and that it didn't exist for religious purposes. So this was because the religious aspect was just CYC's aspiration that the facilities be managed in a Christian spirit, and aspirationally that anyone who attended the facilities would be aware of this. Notwithstanding that conclusion, the judges in the majority actually went on to consider whether a doctrine of CYC might have been infringed. So at the time, the Victorian legislation just referred to the phrase doctrine, or the word doctrine. It didn't use the phrase doctrine, tenets and beliefs like the amendments to the Marriage Act. So Justice Maxwell in that decision concluded that the relevant doctrine was plenary inspiration, so the Bible being divinely inspired and then interpreted literally. So it didn't follow that CYC's view on homosexuality was also a doctrine, but rather this was considered to be an application of the doctrine, so more akin to a belief. Now, the majority also did not consider that the proposed action, so declining the booking, was actually necessary to avoid injury to the religious sensitivities of people of that religion. So it would need to be shown that the proposed action would be an affront to the reasonable expectation of the adherents of the religion. And in this regard, it was noted that any view on sexuality was only a prohibition on the adherents of the religion. So it wasn't to be imposed on non-adherents on the basis that Christianity doesn't expect non-followers to comply with our beliefs. So in the court's view on this matter, they weren't sufficiently satisfied that this would or should cause any injury to the religious susceptibilities of adherents. If the CYC premises had been a church premises, that conclusion might have been open to the court. In this case, though, there wasn't any relevant connection between the Brethren religion and CYC's accommodation business. And I think the quote from the court was that it was wholly unsurprising that no steps have ever been taken by CYC to prevent its camps by being attended by persons who are in same-sex sexual relationships. So to contrast that relatively narrow view set out in the CYC case, we also have another case to look at, which is OV and OW and members of the board of Wesley Mission Council. And that's a case that came out of the New South Wales Court of Appeal. So the Wesley Mission case involved a same-sex couple, and they applied to become foster carers through the Wesley Mission, and their application was rejected on the basis that they were in a same-sex relationship, and they complained to the New South Wales Anti-Discrimination Board, and the Wesley Mission then argued that they were exempt under the religious sensitivities exemption, which was available to them under the relevant New South Wales anti-discrimination legislation. So this case went through a couple of iterations. It was considered in the first instance. It then went on to appeal from the appeal panel to the Court of Appeal, and then it was remitted for rehearing. The appeal centred on the interpretation of the phrases doctrines of that religion and adherents of that religion. So in the first instance, in concluding that the exemption didn't apply, the court had actually held that the religion was Christianity, rather than a subset or a denomination of Christianity. And then they also held that doctrine needs to have a source in significant religious texts or oral traditions. So given the very broad range of views regarding sexuality within the Christian faith, the tribunal felt that they were unable to conclude that a doctrine had been breached in this instance. On appeal, the court held that it was not uncontroversial to use the Common Dictionary definition of doctrine, which was a creed or body of teachings proclaimed by ecclesiastical authorities as true, rather than the definition that had been used in the tribunal originally. So importantly, the court rejected this narrow interpretation of religion, and they held that the focus should instead be on the doctrines or adherents of the Wesleyan mission specifically. The complaint was then remitted to the tribunal for rehearing, and at that time it was dismissed for other reasons. Importantly, however, the New South Wales legislation at the time wasn't the two-limb test, so the Wesleyan mission didn't need to prove injury to religious susceptibilities. So reflecting on those two decisions, we do have a competing view set out in each as to whether we can interpret the concept of doctrines, tenets and beliefs narrowly. In the case of QB, that would be the specific doctrines, tenets and beliefs of QB as is set out in the Assembly statements. But there's certainly judicial authority in the Wesleyan mission case to presume that this can be relied on for the time being, and an argument is there to be made if any issues do arise from this. Importantly, the legislation in the Marriage Act extends to tenets and beliefs rather than simply doctrine, which is used in some state anti-discrimination legislation. So there is a strong argument that even if QB's views on marriage and sexuality cannot be expressed to be a doctrine, they could be considered to be a belief of the denomination. So until a case like this proceeds all the way to the High Court, this will remain a little bit uncertain. Fortunately, in the Marriage Act amendments, there is also this new Section 47C. So a third defence is available, and that states that the minister may refuse to solemnise a marriage if it is not allowed by their religious beliefs. Now, this clearly refers to the minister's personal religious beliefs rather than the doctrines, tenets and beliefs of the denomination. So it's a little bit easier to argue their specific beliefs as opposed to having to determine what is actually a doctrine of the denomination. So we would anticipate that this would be the easiest defence to rely on in the event that objection on the basis of doctrines, tenets and beliefs or religious susceptibilities might fail. This would be a bit of a catch-all provision in that regard. Now, this is another new section in the Marriage Act, Section 47A, and this is the same protection for religious marriage celebrants as is set out for ministers of religion. Now, religious marriage celebrants are generally not required to be connected with any denomination, so they don't have to set out doctrines, tenets and beliefs or any evidence that their actions would offend the religious sensitivities of adherents. They just need to demonstrate that their personal religious beliefs don't allow them to solemnise the marriage. And again, the grounds of refusal aren't limited by this section, so it is quite broad. Now we'll look at this other new section, which is Section 47B of the Marriage Act. This is an interesting one and probably the area where we would look and say, oh, we're not sure if the protections for religious freedoms that really need to be established have actually been sufficiently set out in this section. But we'll take you through what this says. So Section 47B of the legislation provides that a body established for religious purposes may refuse to make facilities available or to provide goods and services for the purpose of the solemnisation of a marriage or for purposes reasonably incidental to the solemnisation of a marriage if that refusal conforms to the doctrines, tenets and beliefs of the religious body or is necessary to avoid injury to the religious susceptibilities of adherents of that religion. Now, the grounds upon which a religious body can refuse to make facilities available isn't limited by the legislation. So as long as one limb of the test set out at 1A and 1B can be satisfied, so either it conforms to the doctrines, tenets and beliefs of the body, or it's necessary to avoid injury to religious sensibilities, then that will be sufficient. Now, the wording of section 47B draws on terms that have, as said earlier in this webinar, been previously considered in relation to anti-discrimination legislation. So there is some judicial authority that's available to us to provide an indication of how this section might be interpreted. So firstly, we need to look at the phrase body established for religious purposes. Now, this phrase isn't defined in the legislation, but it would be, to us it appears clear that if a church is a body established for religious purposes. So the position for related entities such as schools or care arms is much less clear. And section 47B actually refers to a provision of the Sex Discrimination Act, which is section 37 of that act, which excludes by implication religious educational institutions. And the Victorian Court of Appeal case, the CYC case, which we discussed earlier, also supports that approach when it concluded that the camping entity was not a religious body. So while we cannot assume that this will apply to churches, it would be prudent to assume that the exemption that's available under section 47B will not apply to churches separately incorporated entities, such as schools or care arms or other associated entities. Now, we also need to look at this phrase, the purpose reasonably incidental to the solemnisation of a marriage. So we just note that the legislation states that the purpose that the refusal is made must be intrinsic to or directly associated with the solemnisation of a marriage. So we would consider that the hire of a facility for a same-sex marriage ceremony to be performed is intrinsic to the solemnisation of a marriage, and so therefore that would be covered by this exemption. Likewise, we would consider the hire of facilities for example, a wedding reception. We would consider the hire of facilities for example, a wedding reception or a location for wedding photography associated with same-sex marriage. That would also be sufficient to be subject to this exemption. But again, a case-by-case assessment would need to be made. Now, this section uses the same phrases as the other sections that we've looked at already, so it needs to conform to the doctrines, tenets or beliefs of the religion of the body, or is necessary to avoid injury to the religious susceptibilities of adherents to that religion. So that obviously uses the terms that are available under the Sex Discrimination Act and also some other discrimination legislation. So we've been through the competing judicial views on what amounts to a doctrine, but fortunately the legislation here does extend to tenets and beliefs. So we would think that QB's doctrines, tenets and beliefs on sexuality and marriage are set out in the various assembly statements on this issue, and they're relatively clear. So churches should certainly leverage off these documents to avoid any potential conflict or confusion. QB would certainly take the view that the use of church facilities, I would imagine, for purposes purporting to be associated with same-sex marriage, doesn't conform to those doctrines, tenets and beliefs. Now, the separate exemption applies where injury to the religious susceptibilities of adherents might occur. And again, I would imagine that QB would take the view that the use of church facilities for purpose associated with same-sex marriage would cause that injury. It is important to consider what facilities that these exemptions would apply to. Now, the drafting of 37B doesn't make any reference to the ownership or the general use of the facilities that the section would apply to. So we've needed to do some consideration around the terminology. And in our view, The exemption provided by this section should apply to any facilities that are under the control of a body established for religious purposes. So if facilities are both owned and permanently occupied by a church, it's clear that the facility is under the church's control to make available. And in these circumstances, we consider that the exemption would apply. Likewise, if facilities were owned by another entity but leased by a church, the church has effective control over that premises during the duration of that lease. So we would consider that that is also sufficient for the exemption to apply. As the legislation doesn't place constraints on the type or the general use of the facility, we would suggest that the exemption will apply to all facilities within the control of a church or another body established for religious purposes, despite the facility's normal use or purpose. So, for example, a hall or another facility on the grounds of a church property would fall within the ambit of this section, despite not being designated or generally used as a place of worship. However, there is that CYC decision which suggests that where the premises are not being used as a place of worship, it would be difficult to demonstrate injury to religious susceptibilities. But given that the exemption can apply where the action conforms to the doctrines, tenets and beliefs of QB, however, we don't think that proving such an injury is actually necessary. We can contrast ownership or lease of a premises by another entity with a premises that is owned by another entity but licensed by a church. So, for example, a community space where the church has a license to use that facility at certain times during the week for church activities, but they don't actually own or lease the entire property. So in these circumstances, we consider that the church does not have sufficient control over decisions to make those facilities available for the purpose of same-sex weddings. And in those circumstances, the exemption is unlikely to apply. And as we identified earlier, where the facility is owned by an associated entity, which is not a religious body, so for example, a school that is associated with the church, then the exemption available under Section 47B probably won't apply. However, where facilities are owned by the church but leased or licensed to an associated entity, for example, a religious education institution, it may be possible to bring the power to make facilities available for the purpose of Section 47B back within the power of the church. And this could be done by making some strategic amendments to the lease or the license documents that prohibit the use of facilities for these purposes. So we can obviously help with this and look into this arrangement for your churches and associated entities if you would like us to do so. Now I will just bring your attention to another section in the new legislation. So the Marriage Amendment Definition and Religious Freedoms Act actually passed amendments to other legislation, not just the Marriage Act itself. And this section on screen actually makes an amendment to the Sex Discrimination Act. So the Sex Discrimination Act previously provided an exemption for ministers of religion to be pursued for discriminatory conduct under that act by performing marriages within the traditional biblical view of marriage. Now the Sex Discrimination Act has now been amended to provide that a minister of religion may refuse to solemnise a marriage despite anything in this act if any of the circumstances mentioned in paragraph 47 of the Marriage Act apply. So basically those were the provisions that we've stepped through, which looked at the doctrines, tenets and beliefs of the body, the religious sensitivities, or also the personal religious views of the minister. So essentially we can say that if a minister of religion follows the requirements set out in the Marriage Act to refuse to solemnise a marriage, then they also would not be able to be pursued under the Federal Sex Discrimination Act. And that exemption also at clause or section 2AA also applies to people who are registered as religious marriage celebrants, not just ministers of religion. Okay, so now we'll look at some of the practical implications. I know that we've talked about practical matters throughout this webinar, but I think the most important thing that we're identifying for all of our denominational clients and clients associated with religious bodies in general is to ensure that the doctrines and the tenets and beliefs of the denomination are set out very clearly in any policy and positional statements. And in terms of QB, this has very clearly been done by QB's assembly statements on the issue of marriage and sexuality. Now, it's one thing to have those positional statements in place. It's another thing to actually follow them. The concern at the moment for a lot of denominations is consistent application of those statements. So it's really on everyone in the denomination to ensure that they are very consistently applying the various policies that are set out by the denomination, to be very careful that they're not setting any kind of precedent that goes against those. So that's definitely something to keep in mind moving forward. Then on the issue of religious marriage celebrants, it's open for unregistered pastors to seek recognition as a religious marriage celebrant if they are also civil celebrants and qualify under the definition of minister of religion. Now here it's not enough to just be eligible for registration, but they have to actually go through an approval and registration process. So there are forms available through the Attorney General's office for them to do this. So if you have any unregistered pastors who are also registered civil celebrants, you can recommend that they go through this process. Now, as I said, the issue of churches and associated entities making facilities available is probably the issue where we would say that the religious freedoms that the Act sought to impose are potentially not sufficiently protected, particularly for schools and associated entities. So you can rely on the fact that churches aren't required to make these premises or facilities within their control available for solemnisation of same-sex marriages, but be aware that this exemption is very unlikely to apply to associated entities unless there's a very significant control over the premises or the facilities by the church. And that really comes down to a close link in the associated entities, so linking the ministry and the mission and the beliefs of the entities. And in this regard, it would be necessary to review any of your constituent documents like constitutions to establish this link, as well as on a more practical day-to-day matter, there would need to be a visible connection between those two entities. So the CYC decision is the relevant one here because CYC wasn't closely associated with the church and it carried out secular activities without any real religious input. And so in that case it was held that they were not a religious body and the exemptions available did not apply to them. And any public communications such as your website would also be relevant evidence there. And then ensuring that a consistent approach is maintained across the denomination is also essential in that regard. Now, obviously, these amendments to the Marriage Act have raised a wider discussion in relation to religious freedoms and how our religious freedoms are protected at law. And certainly the Ruddock Review into Religious Freedoms, which was announced by the Prime Minister late last year and carried out early this year, had very broad terms of reference. So although it was set up in response to the public discussion around this issue that came out of the Marriage Law Postal Survey and the Changing Marriage Act, there was much broader terms of reference and they were able to consider any issues that they thought were relevant to the issue of religious freedoms and how they are protected at law. So submissions to that review have now closed, but from the submissions we've seen, they address a very wide range of concerns. One of them being the fact that Section 47B of the Marriage Act doesn't extend to associated entities. But there are also issues raised around schools, for example, regarding curriculum, and also the need to strengthen anti-discrimination legislation exemptions for religious entities and associated entities like schools and care arms. I understand that there were about 16,000 submissions to that RADIC review, and we're expecting the report to be released on that by the 18th of May. So it will be interesting to see what comes out of that. But for the time being, it's important for religious organisations to continue to advocate strongly for the protection of religious freedoms in our legislation. So that brings me to the end of the issues that I wanted to address throughout this webinar, but I'm more than happy to take any questions that you might have.
Thank you, Jessica. We're going to give just a couple of minutes. If you have any questions, please do enter them in the chat box on your left-hand side. And just before we wrap up, I just wanted to bring your attention to the next webinar, which is on the 24th of May, on understanding vilification and discrimination. And you can click the link below for that. I can see that some questions are coming through, but just a quick note is that the recording is going to be made available partway through next week, so you can look forward to that. A number of different issues we've covered today, so you can look forward to the recording next week. Check that on our website, and I'm sure, yeah, you can watch it again and share it with anyone who might have missed out today.
So I've seen a question come in from Philip. So his question is the fact that the Baptist marriage rights still state that they apply exclusively to a man and a woman mean that a Baptist pastor cannot solemnize a same-sex marriage even if they want to? Good question. This is certainly something that's come up for a number of denominations recently, where individuals who are credentialed or ordained by a particular religion want to use their ability to conduct marriage ceremonies to actually conduct ceremonies for same-sex couples, and that has required us to look into the specific, I suppose, restrictions that denominations provide to their ministers, and whether that actually goes against the requirements of their ordination or their credentialing. Certainly we think that it is available for denominations to ensure that their ministers and pastors are unable to conduct same-sex marriages. I think that's certainly an option. It's just a matter of whether the relevant documents that you have in place actually allow you to do that. So I'm more than willing to look into that issue for you further. Another question that's come in from Leon: would it be beneficial for churches to state their premises will not be available for same-sex marriage in their policy for use of premises? Leon, I don't think it could hurt. Certainly any policy documents that the church has in place will become relevant in actually determining whether that exemption that is available under Section 47B applies. Whether it is wise to publish that, I think that's a different issue, but certainly if that is included in policy documents, then I think that would be a wise step, and is unlikely to raise any adverse opinions unless it was published.
Fantastic. Well, it looks like we can't see any more questions being typed in, so we're going to bring this webinar to an end. Thank you so much for taking the time out of your afternoon to join us. I hope you got a lot out of it. And yeah, as I said earlier, recording is going to be made available partway through next week. So yeah, thank you for joining us, and have a great afternoon.